Hey everybody, it's your girl Simply C from Let's Talk Money. Happy Black History Month. This week we'd like to honor Thurgood Marshall. Thurgood Marshall was an American lawyer and civil rights activist who served as Associate Justice of the Supreme Court of the United States. He served from October 1967 until October 1991. Marshall was the court's first African American justice. He is one of the individuals who have paved the way for our guest today, who is the Honorable Judge Mark Stiles. Take a listen to this video and don't forget to subscribe and like the video.
Here, we're going to piggyback off of the show we did on estate planning, and we have the honor of having Honorable Judge Mark Stiles.
And the crowd goes wild.
Yes, he is a judge in Division 19 of the Jackson County Circuit Court. He was appointed to the bench as Deputy Probate Commissioner in 2014. He is educated. From the Thurgood Marshall School of Law at Texas Southern University, and he has a bachelor's in finance from the University of Missouri at Columbia. So, Judge Stiles, welcome.
Welcome.
Thank you both for having me.
It is an honor for you to be here. So, we're going to talk about estate planning. Matter of fact, do you have anything else you want to tell us about yourself?
And just first of all, just thank for both of you the invite to get me here. Whenever I can, I love just talking to other people, whether it's one or two or 1,000 or 1,000,000, just getting this type of information across. You guys said that we're piggybacking off of a estate planning session you guys did recently. Everybody has an estate plan. You may not know you've got one, but we've all got an estate plan. The question is, who's in control of it? You or the state that you live in. There's an estate plan for you when you pass away or when you're disabled. And so I'm hopefully going to give everyone some tips on kind of how we can navigate our estate plans today, take more control of our assets, our finances, and make sure that we're good stewards over what we've been given, and then keep going from there.
I like that.
Man, you have one whether you know it or not.
Exactly.
So what exactly is estate plan? We just want to recap that too. So can you share that?
Absolutely. And I'll kind of cover a little bit what I do as a judge for Jackson County. To answer your question directly, an estate plan is just planning for your death or disability. A lot of us think that we're going to live forever, but we're not. A lot of us grew up in church, and so, hey, I'm going to keep living until God comes back, and that's when I'm going to go, but that's not likely going to happen. Also, the stats say that about 85% of us will become disabled at some point in our lives, meaning that there will be a position in our lives where we need someone else to make decisions for us. And so when that percentage is that high, why don't we plan for it? Why don't we plan for our disability? So estate planning is simply planning for your disability and planning for your death. That way, as we all know, we've lost loved ones. We've had to deal with loved ones in crisis situations, and the chaos and the struggle of just dealing with that is tough alone, yet to try to deal with financial and health decisions or dealing with assets and property, that makes that issue so much more worse. And now you've got family that when we're emotional, we fight. And so we will have family members come out and fight with each other, and it makes the situation worse. Again, thanks for letting me be here. I've been on the bench for 7 years. For Jackson County. My primary areas, and we'll try to cover some of these that I cover. A lot of people don't know the probate judge will deal with civil commitments. And so a civil commitment is any person that has a mental illness and they're a danger to themselves or others, threatening suicide, they're so mentally ill they can't take care of themselves, or they're dangerous to someone else, believe these delusions and they may hurt someone. That person will come to my court, and I can civilly commit them to psych hospitals for a certain amount of time to make sure that they get the treatment that they need. And we are allowed to do that. We give them due process. They get an attorney. They get a lot of rights. But the premise behind that is that if you can't on your own, make up your mind to seek the help and treatment that you need. A mental illness is just like any other illness, like cancer, diabetes. If you won't get it on your own, the courts have the power to do it for you. And so I do a lot of civil commitments. As you guys know, mental health is a big issue. And so we do a lot of civil commitments for folks. I handle on that line sexually violent predators. And so sexually violent predators are the people. I don't do the criminal case. So that's someone that molested kids, raped women, and they either pled guilty or found guilty. I don't do that case at all. That case deals with the victims and the specific facts. They've pled guilty. They've been found guilty. They go to jail 5, 10 years, 30 years, and then they're about to be released. But because that crime was so serious, because they molested so many kids, because they raped or such a violent crimes, the state says, hey, if we let this person out, they're going to reoffend. And so then I deal with that trial, which is more of a civil commitment, and it's more medical evidence. And so we're hearing medical evidence on if this person has a mental abnormality. And because of that mental abnormality, they're going to reoffend and commit another violent sex crime. And then what I'll do is determine whether or not they are. And if they are, we'll commit them to a hospital for treatment until they overcome that mental abnormality. So those are the two that I want to get those out the way, because we won't talk about those today. But what we're going to talk about today is I deal with anybody that dies in the county, Jackson County, and they need assets that need to be distributed to the heirs, to the claimants, to debtors. I deal with all those, and that's what we'll talk about. Minor guardianships, adult guardianships. So in a minor guardianship, when you've got a minor that has parents that are unfit, unwilling, or unable, they're deceased, they're in jail, and we need someone to take care of that kid, then we'll appoint a guardian for that minor, whether it's a grandma, aunt, uncle, sibling, and they can make the decisions for the minor. Also, minors will receive money sometimes. That's a minor conservatorship. And we'll talk a little bit about that and how that plays into estate planning. But if there's a conservator appointed, not only do I appoint the person to handle the money for the minor, I supervise. And so that's the majority of my work, is supervising these fiduciaries I appoint, whether it's a conservator, a guardian, a person representative in a decedent estate. And then the adult guardianships and conservatorships, that's someone, we've seen someone that's had a stroke, dementia, they can't take care of their decisions anymore, traumatic brain injury, or born with birth defects. And so you need to get a guardian conservator appointed for them once they turn an adult. We'll do that. A lot of times they're contested. Most times they'll go straight through. But we'll appoint that person, and then again, we supervise them for the life of this person to make sure they're spending their money right, placing them in the right place, not consent to medical treatment that shouldn't be done. And so a lot of people think that once a guardian's in place, they can abuse it. But when we're over it, we can provide oversight to that person as they go through. That's kind of the gist of what I do as a probate judge. A lot of people don't know that we do that much.
That is a lot.
It is.
I'm blown away.
And I talked a lot. I talk fast. If I need to slow down, make sure you guys.
I'm trying to keep up.
Make sure you guys tell me to slow down, because I'll talk fast. But that's kind of the gist. And then hopefully we'll go through specifically the guardianships and conservatorships and the decedent estates, kind of talk about how estate planning plays into those types of areas of law, and then how our listeners can do what they can to kind of help preserve their assets, and not just preserve their assets, but protect themselves and their loved ones from unforeseen issues, and being ready for what can happen.
So what happens to our property if we become incapacitated and don't have a plan?
Got it.
Told you we're going to hit something.
I told you.
I'm being really careful. You see, I'm a statue.
I'm going to hit something every time.
So what happens to our property when we become disabled? Well, nothing really happens to it. I'll give you a good example. You've got someone, and one example, I do a lot of presentations, an elderly woman, and she's got this lifelong goal of owning this houseboat, and she's been paying on it for all the years. She can't get it yet until she pays it off. But all of a sudden she has a stroke and goes into the hospital. And in the hospital, she can't pay the bill to keep that going. And so what happens to our assets, if we're disabled, there's no one in place to make sure that our life is going as smooth as possible, to make sure our bills are being paid. And so that's what happens to our assets, is when we are not able to handle that. And remember, I said it's 85% of us will go through a time of disability. And if we know that that's that high, then what are we going to do? If we know there's a chance that I may be disabled and I can't take care of my assets, I can't pay my bills, what should I do? What you would do is, and we call those durable powers of attorneys. So there's two types. You have a durable power of attorney for financial decisions, and a durable power of attorney for healthcare decisions. And usually there are 2 documents. And what I want to do is try to give you all, the listeners, as much free advice as possible. I'm not a lawyer anymore, and so I can give you advice and not get burned. The state of Missouri, I know everybody may not be from the state of Missouri that's listening, but the state of Missouri has a free durable power of attorney healthcare form. It's a very good form. All you got to do is Google it for Missouri, and you'll get a good form. And what that form will do is, if, let's say that example, I'll call her Birdie. If Birdie is disabled and has a stroke, if she names her son as a durable power of attorney for healthcare decisions using this form, she fills out the form. One thing that's important is she fills out the form. He doesn't. She fills it out and she signs it, giving her the authority to do it. He can then, when she's disabled, place her in the hospitals that she needs to go to. He can consent to medical treatment that she needs. He can consent to whatever medication she needs. If it's something as serious as an amputation, he can consent to that. But keep in mind, what would happen if she didn't do that? What if she needed all these services and didn't do this durable power of attorney for healthcare? She would have to go get a guardianship through my court. Now, usually, so I gave you guys the free form. That's free for this healthcare power of attorney durable. To get a guardianship in Missouri, you're looking at $2,000 to $5,000. And so a free DPOA, we can do that now. Everybody should do it, or you have to wait, and failing the plan could cost you $2,000 to $5,000 to get this guardianship, to get an attorney. Attorney files the paperwork in my court. I appoint an attorney for Birdie, and then they have to do their investigation. And so you've got time that could be wasted, and she's not getting the care that she needs. And so that's a very powerful document, the durable power of attorney for healthcare, that everybody should have, naming other family members or other people you trust to make those decisions for you. Again, I say name someone you trust. There's a lot of times you can appoint someone in there. Oh, I'm gonna just appoint my oldest son or my oldest daughter. Well, don't just do that if you know you can't rely on them when the time comes.
Right.
Question?
Well, I was wondering if there's also one that you can do for finance.
And that's the other one, the durable power of attorney for financial decisions. So there's 2. The free one, Google it, Attorney General's Office for Missouri. You can get it. For the financial one, that's not free. You definitely want an attorney to do that one because there's more liability there.
I was hoping it was, we have one,
Yep.
but I was just hoping it was a free one for the audience.
And the reason why is because that's the one people get sued on the most.
Okay.
That's the one where, and I had a case this week where they were fighting over this durable power of attorney. And what happened is you had 3 children, 2 boys, 1 girl. And in the case, he was basically taking care of Mom. I believed him when he said that he was taking care of her. The other 2 is kind of out doing their own thing. He was the financial DPOA. But what he did, which is going to be problematic, is that while he was using that DPOA, he moved her money from her account into an account that he was the joint owner of. It wasn't his money. And so then that's called conversion. He is now taking control of her money using this DPOA that wasn't his. And so he's liable for that. And so that's why you want an attorney to do that for you, to explain all the powers, because in her DPOA, there was no clause in there that said she could make gifts to him. And so that was a gift. He basically said, hey, this is a gift. She's giving me her money to me by doing that. He probably didn't know he was doing a gift, but that's what in effect he did. And if without that clause that she's making a gift, he's going to be liable for that whole amount that he took possession of and put in his joint account. And so that's why you want to get an attorney for the financial DPOA to actually list the specific clauses, because that's what they do. They say what you can do: open my mail, sell my real property, open my accounts, close accounts, make gifts. All these powers would go in there, and you, as the attorney, in fact, are telling the attorney what you want to be done to have this person have the power when I'm disabled. One of the good things about a durable power of attorney is that they can go in and out of being used, and that's called springing. I don't want to get too technical. So that means if I have a stroke today and I've named someone as my durable power of attorney, agent, attorney, in fact, they can act today and pay my bills, whether it's financial health. They can do that, pay my bills, take care of the things I need. Let's say after a month, I fully recover. Then that power goes away. They no longer have that power because I've got it back. I've regained my capacity. But let's say 10 years from now and I have a heart attack and that document's still there, it comes back in. And so that's the magical piece about these DPOAs, they can go in and out of being used versus a guardianship that takes away all your rights, or the general power of attorneys. And I don't like to talk about those. That's the one where someone has the authority to do it as soon as you sign it.
So I have a question, and I might have missed this part. So the person that took the money and transferred it into the joint account. So how would it become a problem? Is it the paper trail, or did somebody say that the money was moved? How would it be known?
Well, and this is how it's known. And so let's use you and me as example. So I've got my money in my bank account. Let's say I've got, I don't have it, $50,000 in a bank account. And then you've got a joint account that there's no money in. And so what joint accounts do, and we'll talk about this, you can't, if I became disabled, you can't access that account. But if you put my money in a joint account with your name on it, you can access it and pay my bills. And so that's kind of an estate planning. You're doing that. But what happens when I die? That money's automatically yours. And that's how you find out. And so my children are going to say, hey, Dad had $50,000. Where did it go? It's yours.
So
and that's where the problem is.
It's when somebody says something.
Yep. And so when I die,
and the fight begins.
Yeah, and that's where because they knew I had 50,000, and then now it's gone. Because if it would have stayed in my account, then it would have been their money. They'd had to go through probate. But what we did is we created a non-probate transfer by putting your name as a joint owner. And as soon as I die, that money's automatically yours. Automatically, you don't have to do anything because you're a joint owner, and that's where the problem happens.
Okay, it's the fight. It's the somebody else knew, and then there's the fight. Okay.
She like dropped the mic because somebody knew.
Okay.
Yeah, that's good stuff. So what about, I know that's an example of property, but what about if it's a child or a senior adult, like a parent you may be caring for? What happens to them?
In what context?
If you're incapacitated, so you're caring for somebody who's incapacitated, and now you're incapacitated, what now happens to their care? Who assumes that responsibility if you don't have that planned?
Got it. And one of the things that the durable power of attorneys do, both financial and health, they'll name successor agents. And so you'll name one person, but then you'll have maybe two backups just in case that happens. Just in case that happens, you'll have these backups when someone either dies or one of the people before them becomes disabled. So that's the benefit of having those documents, is that you can have a backup. Now, if you don't have those documents, again, now we're back in court. You got to hire an attorney. You got to pay all this money to get it. And then you're really having problems because let's say if it was my mom and she became disabled and I didn't have these documents, I don't know. I'll go hire the attorney and pay all the money. But the court may say, hey, Stiles, we don't think you're going to do a good job. And so they can appoint a neutral third party. They can appoint somebody else. And so I paid all this money, and it's unknown for sure if I'm going to be appointed as her guardian and conservator to take care of her health decisions, financial decisions. The court may say, hey, we think you're not going to do a good job. You can't get bonded. You don't have enough corporate surety to back up the funds that she has. And so we're going to appoint someone else. And then that's the risk that I take by not planning. And so that's where we fail to plan, then that's what happens. And that's what estate planning is just planning for these things we're talking about, disability and death.
You put it in somebody else's hands.
Mm-hmm. Yep.
They get to make that decision. That is so wrong.
Yeah.
Like,
and that's why the court system's there. I had a case earlier this week, and we've talked about, with minors. So it was a minor guardianship. It's a tough week from me.
Okay.
A minor guardianship. And the case in this one is where the grandparent actually took the minor from the natural mother because she thought she could do better. I don't want to go into the specifics, but basically she thought she could do better and took the minor and would not turn the minor back. And so that's almost taking the law into your own hands. And so what the mom had to do was hire an attorney and file all this stuff to get, and what happened is I made the decision that the kid goes back. But again, they had to go through all this legal stuff just to do that. And that's where it's just, we see from the court's perspective, we just see a lot where if the people, if our citizens, we don't get along, then the judges, we have to make the decision. And a lot of times our decisions are based off of limited facts. We don't see the whole picture. Mm-hmm. We only hear the case for 2, 3, 4 hours max. And so based on that information, we've got to make a big decision over a little bit. And that's why it's just important. And I'll say this, we disagree, but we've got to understand that before we go to court, you all know your families, you all know your circumstances way better than the judges do. And the more you can resolve amongst each other, no, it's tough, but the more you resolve amongst each other, it's going to be a better decision for your families rather than letting us make it when we've only dealt with a very limited situation.
So are you telling me that I can go take my grandchild from my son and he would have to go get an attorney to get him back?
And it depends. I mean, I'm assuming he'd call the police first.
Well, yeah.
And so if the police are going to say, hey, this is a family issue, we're not going to get involved, then yeah, that means unless sometimes the police will get involved and say, hey, this is dad, you need to give the kid back. But if they don't, and they've got their discretion to do that, if they don't, then he's got to take legal measures. Yep.
Unbelievable.
It's
tough.
is. So I wonder if there was something that she could have done differently. So signing the child over, or some kind of document that says, I'm going to let my in-laws or this child's grandmother take care of her until this date, or something like that. Would that had helped her situation?
And I don't, based on that family dynamics, I don't think so. But what you're talking about is parents, and they do this often, especially if a child is gone with grandparents for a summer, or parents are going out of town and leaving the kid with grandparents or other family members. They can do powers of attorneys, giving the family member, whether it's a grandparent, aunt, or uncle, the ability to make all decisions on behalf of this minor just as if they were the parent. Those documents expire by law 1 year. So that document's only good for 1 year. So it's only temporarily, but a parent can state how long it should apply just if it's less than a year. And so what you're talking about are just power of attorneys that parents will do, giving family members the authority to make those decisions for them.
So is that a free document?
I believe it's a very simple form. You can find that online. Very simple form. If an attorney tries to charge you for that, then you can find a new attorney.
Hey guys, and thank you once again for tuning in to Let's Talk Money.
You can find us here every Monday at 8 a.m. Central Standard Time.
Yes, so be sure to subscribe and hit the bell notification so that you will be alerted every time new content is aired.
Come on, y'all. Tell your mom and them, your cousin them, all of them.
Tell them all.
Tell them to subscribe and listen to Let's Talk Money.
Yes, and be sure to leave us some comments. Chat with us. We'll be chatting live at times, so chat with us.
Hey, remember, your money mindset matters.
As a man thinketh in his heart, so is he.
Peace, y'all.
Peace.